claims in their pleadings. Cost of the quiet title action. A quiet title action could, in theory, cost up to $100,000 to $500,000 or more, assuming various appeals and trials and a lot of deposition discovery, and that the homeowner is really trying to squeeze out the lender by showing that it failed to perfect its lien in one or more fatal ways. Don't expect the bank to turn over your interest to you quickly. You can expect a long and costly fight in some or even most cases. But this huge amount is wholly unnecessary for most homeowners. My approach is on a step-by-step basis to analyze the cost and benefit at each stage of the litigation so that the homeowner's decision to litigate or keep litigating is cost-effective. Thus, I set a cost based on my anticipated hours of work for the time to be spent by me in reviewing and discussing the facts and the proposed complaint with the clients, preparing several drafts of the summons and complaint, obtaining final approval, filing the summons and complaint, and serving the summons and complaint on the defendants. I call that stage one, and the cost of that is affordable for most homeowners. Here is a typical recent fee proposal for a quiet title action to be brought in New York, which is subject to change of my hourly rate and number of hours for a variety of reasons, including ever-increasing complexity of this type of litigation. Legal fee in advance, $4,500 against $275 an hour. Filing fee payable to the New York court, $210. Service of process, about $400. Preliminary title report, $190. That's a total of $5,210 as openers to get started. If the bank at the outset of a lawsuit doesn't want to settle the action with a reasonable loan modification agreement, then I go to stage two, which is to demand discovery of the bank and others, including third-party witnesses, to find out whether the bank and other defendants have valid titles to the interests in the homeowner's property they claim to own. This could cost somewhere between $1,000 and $3,000 usually, especially if depositions, that is sworn testimony before a court reporter, are kept very short and just seek what is necessary. After obtaining this discovery, I would move for summary judgment, an additional $3,000 estimated, to obtain a judgment that the bank and others have no interest in the homeowner's property, to the extent justified by the discovery so obtained. I would expect the bank to come back with a proposal to settle based on a loan modification agreement rather than run the risk of losing its interest by judgment. If the bank is still unwilling to settle, we will wait for the judge's decision on our motion for summary judgment. If it's favorable, I would recommend dismissal of any claims not obtaining a summary judgment to enable the homeowner to obtain an immediate final judgment and not get bogged down with additional pretrial discovery and trial and appeal on these other issues. This would set off the right of the bank to appeal the decision and judgment, and at the end it is possible that the homeowner will wind up by eliminating the bank's mortgage. It should be cautioned that this does not necessarily nullify the promissory note, but more than likely there would be a reasonable loan modification agreement offered to the homeowner which he or she might not want to refuse. Quiet title actions can work even if you have already lost your property. For those of you who have lost your property, there is some hope. The Ibanez case in Massachusetts teaches us that foreclosure law provides a result similar to the result when an innocent purchaser buys a stolen watch or a stolen automobile. He or she does not get good title, the original owner gets the watch or automobile back, and the purchaser loses out. Ibanez says that if the bank did not have its title documentation, that is the note and mortgage or deed of trust, in order at the time that it issued a notice of default, it did not have the right to foreclose, and the foreclosure was a nullity, and the purchaser has to turn the house back to the earlier owner. The difficulties in finding a qualified and willing local attorney and saving thousands of dollars by using only one lawyer. I've been getting calls from homeowners in every one of the 50 states complaining about their inability to find an experienced lawyer willing to undertake the quiet title action or wrongful foreclosure action. The lawyer may not want to sue banks. Your matter may be too small for the lawyer. The lawyer may be a transactional attorney instead of a litigator, and often the attorney is inexperienced and doesn't know what to do and doesn't want to learn for your one case. and the lawyer may not want to have a financially troubled client. You can avoid this problem by finding a local attorney, by having your suit be brought in New York. Also, suing in New York could save you several $1,000s by not having to hire a local lawyer when you have found a suitable lawyer outside of your area. Now, to wrap it up, to speak with me about your matter, if you want to speak with me about your own foreclosure matter, you can call me at 212-307-4444 or send an email to me at carlpers2@gmail.com. That's CARLPERS2, a number 2, at gmail.com. Thank you.